Well, for good or for bad, now you get to hear from the lawyer, and I'm going to not draw such fuzzy lines about what may not be good or what may not be bad and what's different, and I'm going to kind of call some things bad and some things good. So we talked about the Me Too world, and what is the Me Too world? And if a picture paints 1,000 words, I think that's a pretty good summary. The Me Too movement, I think as most everybody knows, kind of became viral in about October of 2017. So much so that Time named as its persons of the year the silence breakers, those women who came forth, finally spoke out, used social media as a platform, called people out for bad behavior, and then a number of big figures started to topple. Bill Cosby kind of led the charge for a couple of years. Then Harvey Weinstein was the next big one to fall. Al Franken, Matt Lauer, Charlie Rose, and Bill O'Reilly all felt the wrath of the viral Me Too movement. But the question I have, is it really any different? If we look back a little ways, we look at what's happened in the past. In 1990, Clarence Thomas was nominated to the U.S. Supreme Court, and he was caught up in a rash of accusations about sexual harassment. Thomas was nominated in 1990 by George H.W. Bush, but prior to that, under the Reagan administration, he had served as actually the chairman of the EEOC. And Anita Hill, his accuser, was a lawyer working for him at the EEOC. So the very chairman of the agency designed to enforce the rules was accused of violating himself. Survived anyway, became a Supreme Court justice. Next, Bill Clinton. Of course, I think everybody's familiar with Hillary's older husband. But Bill Clinton himself had a few run-ins with accusations ranging from sexual harassment all the way up to sexual assault. James Carville, one of his political advisors, famously said, if you drag $100 through a trailer park, you never know what you're going to get. Hillary Clinton herself referred to the number of accusations as bimbo eruptions. And I think that is a difference between then and now, because at that point, the women weren't to be heard. If you spoke out, you were going to be attacked, and it was an effort to try to silence. So there was a difference back in that time. What are the enforcement statistics today? How much is the Me Too movement had an impact? Well, in looking at the EEOC statistics for fiscal year 2017, which ended September 30, 2017, overall, there were 84,000 plus charges of discrimination filed with the EEOC. That, of course, includes disability discrimination, race, religion, other forms. What about sexual harassment? Of those 84,000 charges, not even 7,000 of them were sexual harassment. Just under 8% of the total charges were for sexual harassment. Compare that to almost half the charges were retaliation. People accused their employers of retaliating against them for speaking out on one of the protected classes. Race was about 34% of the charges, and disability was about 32%. The other thing the statistics show when you dive a little deeper is every year since 2010 through 2017, there has been a slow but steady decline in the number of sexual harassment charges filed. So again, the question is there anything really different? Well, as we talked about, the Me Too movement became viral in about October of 2017. In that same month, the EEOC announced some training initiatives for employers nationwide, both for staff and for supervisors. For supervisors, was a program called Leading with Respect, and for staff, Respect in the Workplace, all focused on what's proper workplace behavior, what's acceptable conduct, how to address it. The Me Too movement, which actually has begun a number of years ago, but it caught fire itself. Now it has its own webpage. It has support resources, discussions, all to support women or any victim of harassment to speak out. The Illinois legislature has taken action recently. They amended the Illinois Human Rights Act. They also amended the State Employees Ethics Act to require government agencies, public bodies, to adopt a sexual harassment policy and to implement it. They also required the Illinois Department of Human Rights to implement a hotline so that employees in Illinois can call and report harassment in that manner. The expectation of it is that going forward, at least for fiscal year 2018, we're going to see an uptick in sexual harassment complaints. That remains to be seen. So cutting to the core of it, what is sexual harassment? There's two laws that actually kind of govern. There's a state law and a federal law. The state law is the Illinois Human Rights Act. And interestingly enough, the Illinois Human Rights Act typically only applies to employers with 15 or more employees. So ordinarily, if you have less than 15 employees, you're not covered by the restrictions or prohibitions in the Act. However, there is an exception in the Illinois Human Rights Act that if the complaint relates to sexual harassment, disability discrimination, or pregnancy discrimination, all you need is one employee. So if they make a complaint on one of those three categories, including sexual harassment, you're covered by the Human Rights Act. And the Human Rights Act defines sexual harassment as unwelcome sexual advances, requests for sexual favors, or sexual conduct when, one, your submission to that conduct is made a term and condition of your employment. Two, your submission to the conduct or your rejection of the conduct is used as a factor in an employment decision, such as I won't hire you if you don't, or I won't promote you, or I won't give you a raise, or I'll fire you. Or the conduct is so ongoing as to alter the conditions of the working environment and make it a hostile environment. Federal law is governed by Title VII of the Civil Rights Act of 1964, which prohibits discrimination of all forms, again, race, religion, sex, disability, age. Now, Title VII applies to employers with 15 or more employees as well, and there's no exception for sexual harassment under Title VII. So again, to be covered under that, you have to employ at least 15 people. Title VII also doesn't expressly define sexual harassment or expressly prohibit sexual harassment. It just talks about, more generically, sex discrimination. The U.S. Supreme Court in 1986, in a case Meritor Savings Bank versus Vinson, came out and said sexual harassment is discrimination because of sex or based upon sex, and therefore it is covered and protected under Title VII. Not protected, prohibited. The critical issue in determining the sexual harassment is covered under Title VII is that the sexual harassment relates to or results in members of one sex being exposed to certain terms and conditions of employment that are disadvantageous to them that members of the opposite sex are not exposed to. Now, the interesting sort of mutation of this, in 2000, courts in Illinois, at least the Illinois federal courts, defined an equal opportunity harasser. And it was out of the Seventh Circuit Court of Appeals, which covers Wisconsin, Illinois, and Indiana. And in that case, it was Holman versus the state of Indiana. You had a husband and wife who worked for the Indiana Department of Transportation. They each had the same supervisor. And over the course of time, that supervisor sexually harassed both the husband and the wife. Offensive conduct, propositions, lewd gestures, the whole gamut. The husband and wife got together collectively and sued the state for sexual harassment. The court dismissed, saying that the key and the critical issue for sexual harassment is you're exposing members of one sex to terms and conditions that you're not exposing the other sex to. And in that case, this guy was such a pig and a jerk across the board, he wasn't discriminating based upon sex. He was just an equal opportunity pig, and therefore it didn't quite cover it, and it wasn't under Title VII. Now, before anybody here leaves and says, this lawyer told me at a seminar today that if I'm going to sexually harass somebody, I just need to do it to both. This is not legal advice today. This is a presentation. But moreover, the EEOC actually made that argument to the court later, and the court generally stood by its decision, but in a later decision in 2007, where we had another sort of equal opportunity harasser, the court said they will delve into the totality of the circumstances and look at everything. And in that situation, what they found in that case, the harasser was really, the more targeted conduct was directed at women, the more explicit, the request for sexual favors. He talked filthy around the men too, but he really targeted the women, and they found that that was a distinction between the sexes and thus violated the act. So there's no loopholes here for anybody to rely on. The other key factor of sexual harassment is the harassment must be unwelcome. And that again was defined by the courts in the 80s. And that basically means that the conduct was not solicited or invited, and it's undesirable and offensive. That's exactly how the courts defined it. And when the court looks at a sexual harassment case, it's going to look at, again, the totality of the circumstances. They're going to look at the subject of the conduct. They're going to look at how often that conduct occurs. They're going to look at the relationship of the parties. If you have, we'll take male on female harassment, but if the female is encouraging the conduct, starting the conduct, instigating it, readily participating in it, it's going to cut against the notion that that conduct is unwelcome and therefore it's sexual harassment. Likewise, if there's situations where you have couples that work together, the husband and wife, any sexual banter between the husband and wife, given the consensual relationship, is not going to necessarily be deemed sexual harassment. Now, that doesn't mean just because you were once in a consensual relationship with a coworker that there's a free pass forever to harass you, but the burden then becomes on the victim to define when that relationship broke and when that conduct became unwelcome. And the courts, again, will look at the totality of the circumstances, but unwelcomeness is a key factor. As far as what constitutes sexual harassment, I could give the graphic list, and that'd probably be some form of harassment, so I'll talk generally. And when you read these cases, don't lay the cases around your house for your kids to pick up, because some of it's unbelievable what people will do to screw up their lives. But sexual harassment can be verbal, obviously, jokes, comments, propositions, solicitations, requests for dates. That's the obvious. It can also be nonverbal. There's cases where just leering or staring at somebody, grunting, licking their lips, making kissing noises have been found to be sexual harassment. Visual, having pictures or posters in your work area of scantily clad men or women or in compromising positions. Viewing pornography at work, which seems obvious, but some people argue, well, I was looking at it myself. Yeah, but everybody that walks by your cubicle can see your screen, and that could create an offensive environment. Physical is a little more obvious too, the back rubs, shoulder rubs, touching, brushing up against. And in the modern age, text and email. So it can occur after hours, even sexual harassment, through unwanted text messages that are graphic or emails, social media posts. There's two basic types of harassment. There's quid pro quo harassment and hostile environment. Quid pro quo, I can't even talk. Quid pro quo is a Latin phrase basically meaning something for something or this for that. And basically it's the kind of harassment where you rub my back, I'll rub yours. If you submit to my sexual request, I will give you a raise, or I will hire you, or I will do something favorable for you. That's the most basic and was kind of the most obvious form of harassment that the courts recognized. The next kind is hostile work environment. And that's not necessarily where it's that sort of this for that equation. It's just ongoing filthy humor, derogatory comments, crude language that's ongoing. Now the other part of it is that the courts will look at is to be hostile work environment, it has to be ongoing conduct, severe in nature and pervasive. So it just kind of consumes the workplace or the work environment. Occasional or offhand remarks, an occasional sexual joke or sexual reference that isn't pervasive has been held not to be harassment. What the courts say is these laws, Title VII is not a code of conduct of civility. It's just a prohibiting discrimination, and that only occurs in hostile work environment when it's so severe and pervasive and ongoing. And the courts will look at it through the reasonable person standard. What would a reasonable person find to be a hostile or abusive environment, not necessarily what any particular individual would find. There's two ways employers can be liable for sexual harassment. Harassment by a supervisor, harassment by a coworker. When you're talking about harassment by a supervisor, supervisor is the person that the employer puts in a position that can affect directly the terms and conditions of somebody's employment. They can hire them, fire them, promote them, discipline them. And the courts recognize if you put a supervisor, you put somebody in that kind of control over another employee's circumstances, if that supervisor steps out of line, you're strictly liable. So if that supervisor adversely affects somebody's employment, doesn't give them a raise, doesn't give them a promotion, demotes them, fires them because they won't consent or submit to any sexual conduct, the employer is going to be strictly liable. There is no defense at that point. You're going to be paying out whatever the damages are. However, in a situation with a supervisor where there's no direct action, such as hiring, firing, termination, anything like that, it's just more of the hostile work environment, the employer can assert a defense if they can show they had used reasonable care to prevent and remedy any harassment, and that the employee failed to take the opportunity to engage those protective measures. And we'll talk about this a little bit more, but basically that means you need an anti-harassment policy, you need an enforcement mechanism, you need a way to address these type of situations when you become aware of them. As far as harassment by a coworker, there can still be liability, but the standard's a little less and the employer has more defenses. Basically, the employer has to know about the conduct and has to fail to timely act to remedy or address it. And again, that goes to having a good anti-harassment policy, a mechanism that your employees know how to report that, know you'll investigate it, know you'll take it seriously and address the behavior in order to limit your liability. And we talked a little bit on the statistics that retaliation claims make up almost 50% of all those filed. That goes the same with sexual harassment claims. There can be no retaliation against somebody who reports sexual harassment. And that could even be if I see somebody harassing another person and I report that, I shouldn't be retaliated for that, as well as the victims of harassment for reporting it. So you can't be retaliated for reporting it, for cooperating with EEOC or the Department of Human Rights and investigating that, or even for cooperating in an employer's internal investigation of it. And even if the employer finds ultimately, or the agency finds ultimately, that no harassment took place, there's still no retaliation against the report. However, you can discipline if you can show that the report was made maliciously or in bad faith as a try to get somebody else. It's a higher burden, but there is that possibility as well. So what happens in harassment? Well, back pay is certainly one thing. If you fire somebody and it turns out you fired them improperly because they wouldn't submit, you can be liable from the time of the adverse action up until the time the court or the agency renders judgment against you. Front pay as well. If it's deemed it's going to take them a while to find an equivalent position, a court can award pay going forward for a few years. They'll consider a number of factors and what's reasonable, but that's out there. There's also compensatory damages, which is separate from back pay or front pay. That's the emotional distress, the loss of sleep, anxiety, harm to reputation. If you can quantify that and show that you've been harmed in that way, you can recover for that. Now, under Title VII, there are caps or limitations on that based upon the number of employees you have. So if you have 15 to 100 employees, compensatory damages are capped at $50,000. 100 to 200, capped at $100,000. 200 to 500 employees, capped at $200,000. Over 500 employees, capped at $300,000. Now, there's no cap on back pay or front pay, just on compensatory damages. The other nuance of it is there are no caps or limits on emotional distress or compensatory damages under state law. And keep in mind, in the state law, you only need one employee to be liable for sexual harassment, and there are no caps. You can also get punitive damages if you can show the employer was negligent in addressing the problem, indifferent, or even malicious in the way it handled it. The jury can award punitive damages. Although, again, the nuance is you can get punitive damages under Title VII. You cannot get punitive damages under the Illinois Human Rights Act. Both acts do allow for the recovery of attorney's fees as well. So what can you do to protect yourself? As I mentioned already, have an anti-harassment policy. And it should be broad enough to cover all forms of harassment, but it should also detail specifically sexual harassment, define what sexual harassment is, provide examples of it. The Illinois Department of Human Rights has a model anti-harassment policy on its website that's a good starting point. The policy should also provide alternate means for employees to report harassment. And by that I mean, don't just say, if you believe you're harassed, talk to your supervisor, because what if the supervisor is the harasser? So you should say, if you're not comfortable with talking to your supervisor, talk to another member of management, talk to HR, give alternative sources. Under Illinois law, if you contract with the Illinois government, you actually, as part of your harassment policy, have to provide information on how the employee can contact directly the Illinois Department of Human Rights as a means to report it. The policy should also provide a means to investigate any report of harassment, and so that the employer can remedy and address it going forward. And of course, it should include a statement prohibiting harassment. So should you investigate? Well, as we talked about, that's one of your primary defenses. If you become aware of it, you act promptly and you remedy it, certainly you can avoid liability with coworker harassment. If you're aware of it and you can stop it before there's an adverse action taken, you can even limit your liability in supervisor harassment. And don't just wait till there's a complaint by the employee. That's the easy way. You should have your supervisors and managers trained that if they see something, if they hear rumors or innuendos, they see some inappropriate behavior, they hear something else, that should always trigger looking into the matter further. I've kind of already addressed why conduct one. That's your primary line of defense. The other part is your employees will know that this is going to be a respectful environment. It'll help morale, and you'll be making proper decisions. Now, when you conduct an investigation, there's really three things. I have two of them on the slide. Be objective, be impartial, don't delay. If you get a report, act promptly, because again, that's part of the defense, that you acted timely and in a prompt manner to address the situation. But also, don't go in jaded, don't go in with a particular point of view. Oh, this person's a whiner, they're always complaining about something. I'll just do a pro forma investigation and sleepwalk through it so I can document the file. And the reason for that is we doggone lawyers. And what I mean by that is lawyers, in cases where the harassment itself may not be that severe, the next step is to attack the investigation, make that employer look indifferent, make that employer look biased, make it look like a setup or a kind of a con job. There's a case, it was against IBM, where an employee with a 35-year impeccable record made a complaint to HR. This was actually age discrimination, but the example holds. His supervisor asked him one day, when are you going to retire? And then continued to ask him until he complained about age discrimination. They did an investigation timely on his report, and despite 35 years of an impeccable record, high performance appraisals, promotions through the system, he got fired after the internal investigation because they found his performance was suddenly deficient and he wasn't doing his job. And after the jury hit IBM with about a $6 million verdict because of the bad investigation, I think they may have learned their lesson. Who should conduct the investigation if you're going to do one? Obviously, you want somebody knowledgeable about your workforce. If you've broken up into departments, somebody knowledgeable about that department, how the employees interact with each other, how the work flows. Particularly, you want somebody experienced with doing an investigation, how to interview or question people, how to assess demeanor. Also consider the fact that since this is your defense, if a lawsuit gets filed for sexual harassment, that you conducted a prompt and timely investigation, your investigator may be a witness at trial, so you want somebody that's going to present well to a court and to a jury. You want unbiased in no sort of relationships among your investigator and any of the parties involved. This was a case against Chrysler Corporation. Again, not sex, but it applies, and it's a stunning result. Otto May was a gentleman who was a Cuban Jew, and he was harassed for a period of about 2 years at a Chrysler facility based on his religion and based upon his ethnicity. His vehicle was vandalized, his property was stolen, he had little dolls hanging in his locker with threats. Ongoing for 2 years, he complained, and after 2 years, Chrysler finally investigated, and the lead investigator for their internal investigation was the HR specialist who was the wife of one of the men that Otto May specifically said was doing this. And again, the jury hammered Chrysler. The other thing to consider is the job titles of the people being accused. If your CEO, your president, your department head's being accused, you don't necessarily want a low-level HR generalist who could be intimidated or anything like that. Consider who you want, consider the relationship when you're doing it. As far as the investigation, make a plan. Again, don't just wing it. Don't just say, I got this. There's harassment. I'll go talk to some people. Know your policies, know your guidelines, know your work structure. Look at what documentation there may be. If somebody's doing it in text messages, get those texts. If they're doing it by emails, get those emails. If there's video at the entrance or the exit and something occurred on video, get the video. Gather everything before you start doing it. Know what you're talking about. Prepare for the interviews. Gather that evidence. And there's a lot to go into, and I've actually given presentations before on how to conduct a workplace investigation. So again, this isn't advice, and I'm skipping over some of this for the sake of time, trying to hit the high points. But when you're doing the investigation, You want to give it some serious thoughts. You want to make outlines. You want to make a plan. You want to know who you want to talk to, how you want to talk to them, and lay it out. When you conduct the interview, take notes and take lots of them. If you're going after, particularly when you're talking to the victim or the alleged victim and the person accused, you may want to have somebody else in there with you. And that may be just for that person to take notes. I've done investigations of department heads of agencies, higher up employees. When I do those investigations or do those interviews, I typically have another attorney from my office, usually one of the younger ones. That's not age discrimination. They can write faster. I do all of the talking and all the interviewing, and I watch who I'm talking to. I look to assess their credibility. Are they looking me in the eye? Are they fidgeting? Are they nervous? Are they combative? One interview I walked in, the gentleman knew the interview was going to happen and spent the first 10 minutes telling me how offended he was and how out of line it was that anybody would even think that he would stoop to that level, and spent the first 20 minutes arguing with me about the mere fact that we were having an interview. But you may want to have somebody there on the big interviews to take notes, to kind of be a witness for you, and then assess their credibility, as I talked about. Look at their demeanor, consider how plausible their story is. I mean, sometimes people tell you stuff and you're like, people just don't act that way. That doesn't make any sense. Or the documents you have don't support the story. Consider all of those things. There's a myriad of other considerations. Do you record the interview? You got to be careful there. Here's my plug, consult a lawyer. There's the Illinois Eavesdropping Act, which actually says you can't record a conversation, whether it's by phone or in person, unless all parties to the conversation consent. So if you have one person, you're two people in the conversation, both have to consent. If you have 4 people in the room, all 4 have to consent, and so on. So make sure you're not violating that. I mentioned before, get emails and text messages, but if you do that, you got to make sure as well you have a good policy on electronic communications that allows you the right, if it's sent on a work computer, you have the right to go in it and you tell the employees you will be monitoring, you are monitoring. If not, and they have an expectation of privacy in their emails because they don't know you can go in there, they could raise an argument of that, and then you could be running afoul of federal law, the Electronic Communication Privacy Act, the Computer Fraud and Abuse Act, and even the Illinois Eavesdropping Act. Other things to consider, if you've got union employees and you're going to interview an employee for the purposes of possible discipline, under a Supreme Court case, there's Weingarten rights, and that's Weingarten, not wine garden where you go to have a drink. But the Weingarten rights mean that if it's a union employee, they have a right to have a union rep with them when you're questioning them. If it's a public employee, I know there's a number of public employers here today. If you're going to terminate somebody, the government cannot take away your property without due process of law. Those of us who were awake in 8th grade civics class remember that. But if the government's going to take your job away, you're considered as a public employee to have a right to your job. You can't be deprived of that right without due process, which means a hearing and an opportunity to be heard. That's called Loudermill rights, or a Loudermill hearing under another Supreme Court case, Loudermill versus Cleveland Board of Education. If you're going to interview police officers, there's Garrity rights that their statements can't necessarily be used against them. It's sort of a right not to incriminate yourself. There's statutes that govern interviews and questioning of police officers as well. So again, there's a lot to consider. The biggest thing when you do an investigation, make a conclusion. If you set out in your plan to see whether A, B, C, and D were violated, make a conclusion. Was A violated, B, C, and D, and why? And if you can't answer that, put it in the report, what you're missing, why you can't come to that. But make the findings, and typically you'll have your investigator make the findings. In most cases, your investigator isn't the decision maker. The investigator will turn over a report to the decision makers, and they'll say, hey, I believe harassment occurred, I believe it didn't occur, or it may have occurred, but it wasn't severe, and I'm not going to terminate, but I'm going to transfer, I'm going to move, whatever it is. But you need to make a decision. And obviously, if harassment's occurred, you need to remedy the harassment. And again, like I said, if you're not going to terminate the harasser because maybe it was a couple of off-color comments, you feel training or counseling may do it, but you want to separate the harasser and the victim, transfer the harasser, don't transfer the victim, because if you change the terms and conditions of the victim's working relationship or their employment, give them different duties, a different assignment, that can be viewed as retaliation because they made the complaint. So deal with the accuser, be careful with that. And then the last couple slides, basically follow up with the complainant, let them know what your findings were, let them know what the results were, let them know what you're going to do about it. I mean, that includes whether you did find harassment or you did. Confirm what you're going to do. Also, let them know that there will be no retaliation against them. If they feel they're being retaliated by any other managers or coworkers, let you know immediately and encourage them to discuss their concerns with you. And lastly, follow up with the alleged wrongdoer or maybe the actual wrongdoer, depending on the investigation. Meet with them, tell them what you concluded, tell them what you're going to do about it. I would say that you can keep the conversation with the wrongdoer fairly limited if you're going to terminate the wrongdoer. There's no sense in bantering back and forth and arguing. You can just say, here's what we investigated, here's the basics of what we found and why you're terminated, go. If you've got any problems, put it in writing. But if you're going to keep that person, I think then at that time you owe them the explanation of why more fully you're moving them, you're demoting them, whatever it is. And with that, sort of the do's and the don'ts, the good and the bad, I will stop. And Eric can tell you what I did wrong or tell you how to fix it.